Thank you. My question is to Nasser. What if the chairman that signed the arbitration agreement, he got an approval from the board after signing? Does it count here in the UAE?
Thank you. That's very controversial. It depends on the shape of the company or the structure of the company. If it's public joint stock company, then the chairman has all the authorities. If he signed, the chairman of the board, if he signed an arbitration agreement, if it was a public joint stock company, then he has the authority by law. So there is no need for approval after he signed it. Now, if a chairman in a limited liability company that has a board of directors, then we have to go to the memorandum of association and see what are the powers there, how these powers being assigned to each person there. But to give you an answer, yes or no, I cannot. It's very controversial because there are legal theories which approve the latter action, that it's subsidized what's before it. So if there is an approval after an action, it could be accepted, but there is no guarantee from me now. I don't have clear answer to this.
Thank you very much. My question is with Andrew. Do you think the criminal and civil proceeding in litigation, especially in the arbitration, are successful as compared to commercial law and other laws?
Sorry, I didn't catch the first part of that question.
Commercial arbitration is successful, no doubt. It's working all over the world. But how do you think criminal and civil litigation are also successful in this? And what's the ratio, do you think, in this area?
Well, ordinarily, most criminal issues won't be dealt with arbitration. In the future, potentially, but I mean, they're mainly dealt with outside.
At present, I'm asking about presently.
Yeah, presently, most criminal issues are not dealt with in arbitration.
Okay.
Thank you all. Mr. Nasser, just now you refer about precedent in which the court invalidate arbitration award on the cases on the basis that the manager is not authorized. I think now there's a recent judgment which is giving the manager of the company, LLC company, by default the right to arbitrate or to agree for arbitration unless he has been not authorized in the memorandum of association. Yani by default he's been authorized. Going back also to the question, if the authorized person has already approved the for the party who signed the arbitration agreement, if he approve it, is it valid or not? I think also this will take us to also recent judgment, which is giving the right of objection of the capacity of the one who signs the agreement, the same party. And I cannot object to the other party that he signed but he is not authorized. The one who has the right is the same party who authorized already. Thank you.
Thank you for this comment. Yes, I agree with you. So now, in the case that I presented, the manager, that company has so many managers in it. Project manager, the department manager, marketing manager. But that manager who signed, his name was not in the trading license, not in the memorandum of association, not anywhere. He had a power of attorney saying that, just stating his name, he's allowed to run the company and sign agreements. And that's very broad. And that's why the court did not accept this as a correct arbitration clause. In terms of authority and approval, and the rejection of the act that they have done, when all the agreements, all the challenges that I have seen so far during this 20 years were raised by the company that signed the agreement itself. The company comes and say that the manager, our manager, this manager who signed the agreement is not entitled, he's not empowered to sign the arbitration clause. And this is valid. But the other way around is not valid. So other companies cannot come and say the other party who signed the agreement with me is not empowered. Finish. They accepted his representation, and that's all. They had a duty of due diligence and making sure that they are dealing with the right person in that company. Thank you.
Hello to everybody. Actually, it's a question about the Dubai arbitration and China arbitration. Could you please outline the, I don't know, average cost of arbitration in such institution? I mean, except the cost for lawyers, because I have some data. For example, in ICC arbitration, it's around 60,000 euro. In London, it's almost 100,000. In Stockholm, it's about 50,000 euro. Could you please outline these figures about Dubai and China, please? At least minimum cost.
Well, thank you. Actually, I do not have a very clear overview about that. It may depend. For example, there are several major arbitration institutions in China which their fee tables can be different. They are different, and it may depend on the amount of the dispute. And if you compare it with the court fees, you can't say with one word which is higher, which is lower. But also in comparison with other international arbitration institutions. Actually, I would seek for help from Mrs. Xu. Can you say something about it? Because she is an arbitrator herself. Maybe you can say something about the comparison of the arbitration costs comparing with the major foreign ones, SIATAC or Shanghai International Arbitration Center, for example.
Depends on the amount in question, maybe like a fixed percentage. Currently, I cannot remember it very clear. Okay, maybe later on I can email you. Okay.
But I think it's really difficult to just say one conclusion which one is higher. I think it's not possible.
I think the answer is almost the same. I think ultimately it's not about necessarily the jurisdiction that impacts the costs, but more so the rules. And I'm slightly surprised by the statistics that you mentioned, because my recollection is that the LCI arbitrations are actually usually cheaper than the ICC arbitrations. So I just question the accuracy of those figures. But generally speaking, I would say that in the region, it is, and I think Andrew mentioned that we laugh, but probably it is true. Arbitrations are not cheaper than litigation, and primarily because not only do parties and counsel and the procedure cost more, particularly in this jurisdiction or neighboring jurisdictions, because there are no disclosure steps in litigation, but there might be in arbitrations, even though they take place here, because arbitrators simply think that they can import their home jurisdiction rules, even if they're sitting locally. So in my experience, usually litigations in these in jurisdictions in the Middle East ultimately cost less than arbitration. You can look at it quickly and think, well, arbitration is actually cheaper and quicker, but in reality it's not. You have the arbitration, you get the award, then you have to enforce it, and then after you enforce it you have to execute it. So you start where probably litigation ends. So the quick answer to your question is, it depends.
Once again, we are thankful for all speakers for brilliant presentations, and thank you for your attention. Thanks.
Thank you to all the speakers for their wonderful presentation. I would request Igor to please present the memento to the speakers. Thank you. Thank you, Igor.